All right. I'm going to go ahead and start and do our introductions as other people join. I am Lisa Kukura, Executive Director of Gift Planning here at the Catholic Foundation. We want to give a warm welcome to Jeff Althaus, our attorney speaker for today. I want to introduce him as the founding attorney of Althaus Law, who is a Catholic. He's located in North Glen and Longmont. For Jeff, family is the heart of everything. His passion for keeping families together through their toughest court battles began while working for the offices of the Deputy Public Administrator, where he saw the worst family fights over inheritances and other heartbreaking issues. These experiences led Jeff to found his law firm 10 years ago with a mission to keep families together and out of court. Jeff is dedicated to educating and communities about proper estate planning and how to avoid probate court through community presentations, teaching wills and trust as an adjunct professor at Colorado's University School of Law, and via his book, You Only Die Once, an easy-to-read guide on estate planning. Jeff is an attorney who does not sue anyone, a proud card-carrying Hawkeye, go Iowa, who still loves the Broncos and is dedicated to using his over 15 years of experience in estate planning and probate to help people plan for their futures so they can enjoy their present, knowing their legacies and families are secure. We have a slide presentation, and we're going to do this as a question and answer. So welcome, Jeff.
Thank you so much, Lisa. Happy to be here. Thanks for having me.
Great. I presented with Jeff before, not exactly in this format, but here we go. Why, and part of my introduction answered this, I think, why do estate planning, or what are the goals to do an estate plan?
Sure. And I'll try to click through the slides here as we go too, so hopefully everyone can see that, but they'll line up a little bit, not perfectly. But really the main point of doing estate planning is protect your stuff, protect your family, both while you're here and after you pass away. You want to get things where you want them to go. You've worked hard for things throughout your life. Make sure they get to where you want it to go. Keep things out of the hands of the government. You can avoid taxes, which everyone loves paying taxes. So estate planning can help you take care of all those things.
How old are you when you first need a will or a trust?
I thought you were just going to ask how old I was. Thanks, Lisa.
No,
Um,
there you go.
my kids would say ancient. No, I tell people the best time to get a will is yesterday. Um, and really, anyone over 18 can benefit from having some form of estate planning. People kind of look at me like I'm nuts when I say that, but I have clients that have kids that are graduating and going off to college, and what they don't realize, and they end up fixing by getting some powers of attorney for their kids, is that when their kids go off to college and they're over 18, they now, as parents, have no legal authority to access information for their children. And that can start as young as 16, actually, assuming the kids want it to go that way. But at 18, if your kid gets hurt at college and you call the school or the hospital to see where they're at or how they're doing, they won't tell you, unless you have a medical power of attorney where that your child has designated you as the medical power of attorney. Same with financial power of attorney. If there's assets of theirs you need to be managing for them, if they were ever hurt in a car accident or anything like that. So you really can get a plan at 18. You may not need the full shebang at 18, but there are documents that can help everyone after you hit 18.
My own children are ages 33 to 26, and I've told them that too. I'm not sure they're paying attention at this point, but I was just on vacation with them in July, and I emphasized that again. And I actually told them how important the powers of attorney are, because only one is even married. So, on that note, young children, what happens to them if the parents have not done their planning?
Yeah. I think uh, This slide probably starts touching on that, but that's the guardianship is kind of the biggest thing there. So there's the guardianship and then minors inheriting. So young children, if mom and dad aren't around anymore, there's laws that have basically written estate plans for parents, and parents don't realize this, but uh, if you don't designate who's taking care of your kids, who's going to be mom and dad if you pass away, the court comes in and decides that for you. And that's a guardianship hearing. And people also don't realize the expense and time and stress and energy that goes into those. That's You had mentioned my work at the public administrator's office. We worked pretty closely with guardians. We were in guardianship hearings a lot. And there's also another component of that called the conservatorship hearing that happens at the same time. But essentially, the court has to figure out the best interests of a child pretty quick. And there's systems and laws in place that just kind of decide automatically what happens. If you haven't written stuff down, this judge is just deciding what happens to your kid. Children can end up in foster care. A conservator who's a professional usually gets appointed to manage any inheritance or funds that child might be inheriting. And then there's just strangers basically raising your children and managing the inheritance that you left them. And they have no idea how you'd want that kid to be treated. They don't know about your religious backgrounds. They don't know about any of that stuff. They just kind of have a playbook and they run it. So guardianship is probably the most important thing parents with minor children can set up. Usually do that inside your will. Unfortunately, the courts don't care about who you've named as a godparent, any side agreements that you have with relatives about raising your children or anything like that. It has to be an official legal guardianship paperwork, or it just doesn't matter. So that's the guardianship side. The inheritance piece is minors can't inherit under the law because they're not old enough to manage money. The law kind of treats people who are incapacitated, Alzheimer's, dementia, car accident, coma. They treat them the same as minor children. You can't manage stuff because you're not fully functioning. So until you're 18, the law says that if you inherit, we have a guardianship and conservatorship hearing that I just kind of talked about. But those hearings can be over $10,000 to go to. Like I said, you have a professional appointed that doesn't know your kid, and then you get the joy of paying that professional about $400 an hour to manage your child's inheritance. And that's until the child is 21. So there's this weird gap in the law where if you inherit at 18, you get it all at 18. If you inherit at 17, it's locked up in a conservatorship until you're 21. Um, don't know why that gap exists, but it does. And you can plan around it. There's lots of things you can do to stop all that from happening. But um, yeah, that's kind of what to look out for with minor children.
And then your slide addresses what is a will.
Yeah, it's the most worthless document I do. I just like to say that to get people's attention. It might be the most worthless estate planning document out there, but that doesn't mean it's unimportant. It is a very important document. It's just that in a good plan, we're hoping we never actually use your will, because if we're using a will, we're in probate, and we'll talk about that a little later. But a will is just a stack of papers that says where you want your stuff to go, who's in charge of probate, which is just court after you pass away, and then is there a guardian for your minor child. So that's all it does. And a lot of people think, well, I've made a will, I've said who's in charge, I've said where everything needs to go, I've named guardians for my kids, we should be good, right? Like I shouldn't need court or probate. Well, that's wrong. Wills alone do not avoid probate ever. So that's why I say that they're kind of worthless, because in a good plan, we never actually use your will because we avoid probate. And the simplest way to define a will is to say it's just the instruction sheet for the judge to go through probate. Makes it a little easier, doesn't really make it quicker, but it lets your wishes get carried out in court. Estate planning is kind of the answer for how you avoid probate and stay out of court, but the will alone doesn't do it.
And I've presented with you before, so we get to the beneficiary designations,
Hmm.
entitling of assets. I think that is what you're alluding to when you're talking about staying out of probate.
Yeah, so this next slide kind of touches on that too. Beneficiary designations are a great thing to bring up. If people have fallen asleep already, wake up because this is probably the most important thing that I say to people, and it's beneficiary designations are the most important estate planning tool and the most powerful estate planning tool on the planet. And people kind of look at me and it's like, okay, well, what's a beneficiary designation? And it's really there's three types of assets. There's bank accounts, life insurance, and then retirement and investment accounts. Those are beneficiary designated assets, meaning all of those can have beneficiaries on them, which means you can say who gets that asset when you pass away. So on your bank accounts, you can go say, hey, my spouse gets this when I pass away. Or if you're a joint owner on that account, you can say, hey, our kids get this bank account when we pass away. You can do that on your life insurance. You can do that on your 401k, your IRAs. And then that beneficiary, when you die, presents a death certificate to the bank or your financial advisor or whoever, and they then get that asset 100%. And the cool thing about beneficiaries is it avoids probate, it overrides that whole process, it goes straight to that beneficiary 100%, no court needed. And why that can be a bad thing if you don't have a good plan is it overrides your will and it also overrides if you have a trust. So they're very, very powerful. And everyone's homework, you're welcome. I'm a teacher. Sorry, you get homework. Everyone's homework is to go out and double check all of your financial assets to make sure they have beneficiaries on them. If they don't, your homework is then to update those beneficiary designations to whoever you want it to be. My recommendation is always don't have this override your will. It should match what your plan says because, like I said, they win. Beneficiary designations win 100% of the time. Your will could say everything to Lisa, but if your beneficiary is Beth, Beth gets everything.
Whoops, he froze for a minute. Are you back now?
I'm
There,
back.
there you are.
No, that was pretty much it for beneficiaries. It's just um, whoever is that beneficiary, they're going to win every single time.
And I explain that to our donors many, many times because that is a very confusing aspect for them to understand that the beneficiary is designation is different, separate from your will or your trust. So that is something that I find a lot, and I find people have a lot of confusion with that. Specifically, the beneficiary deed. We at the foundation a couple years ago had three different gentlemen, all for different reasons, that left us either all of their homes or a portion of their homes. And that then the proceeds, once we sold it, went to charity. And it does avoid probate. It is a very smooth process. So we've seen that at the Catholic Foundation go for charity. So yes, I think beneficiary deeds are great.
Yeah, beneficiary deeds, since I didn't talk about them much, are basically a deed you can put on your house, like Lisa mentioned, to transfer that. It's putting a beneficiary designation on your house, and it makes that real property, that asset, avoid probate and go directly where you want it to go. And I actually recommend for Catholics a lot to use this is my shameless plug for the Catholic Foundation, to use the Catholic Foundation as a beneficiary because every time you change your beneficiaries in an estate plan, like in a trust or a will or anything like that, you have to pay an attorney. And who wants to do that? If you just name the Catholic Foundation as your beneficiary and then you have an agreement with them of how you want that stuff to go, you can update that agreement whenever you want and you don't have to change your official beneficiary designation. So that's a cool advantage of what you guys do. So thanks for doing that, Lisa.
Oh, it's a blessing, and it is. We try to really help, especially in that charitable aspect. Um, what is the difference, and I get this a lot, between a will and a trust? And how do you know if you need a will or a trust? And then in addition to that, I'm going to layer this. Um, when you have a trust, you always still have a will, and that very much confuses people. So there you go in your layers.
Yeah. I think a few people said my video was frozen, so I apologize. I'm not seeing any lags over here. I just tried to turn it on and off again to see if it fixes it.
You're
But
back now.
um, so will versus trust. There's lots of pros and cons to each. You'll sometimes run into situations where uh, an attorney will tell you you have to have a trust to avoid probate. It's the only way. Run for the hills if you hear that, because that's not true. A will-based plan can be perfect for one individual or couple, and a trust could be perfect for a different individual or couple. It just depends on what your goals are and kind of what your facts are surrounding your situation. Um, so a trust is still a stack of papers like a will. It says where you want your stuff to go. It says who's in charge, and it it doesn't name the guardian. The will still does that, but I have a little slide here on trust. But um, essentially, when you create a trust, you create an entity, and that entity can own property. So while a will is just a stack of papers with instructions for a judge, a trust is still a stack of papers with instructions, but it's not for the judge, it's for your trustee. And you've created a legal entity now. And since it's recognized by the state and can be recognized by the IRS, it can own property. So we actually transfer all of your stuff into the trust, which is kind of weird to think about because if Lisa had a trust, Lisa wouldn't own anything anymore. Lisa's trust would own everything. But then when you pass away, a judge looks at you and they're going to analyze whether you need to go to probate or not. And there's two things they look at. One is, do you own real property? And if your trust owns your house and any land or minerals or any rentals you have or anything like that, you don't own any real property. So prong one is not met. You don't need probate for that. Then the judge goes to prong two and they say, Lisa, how much money do you have in your individual name? And they're looking at $88,000 is the limit in 2026. That number changes every year. Usually goes up, so it'll probably be around like 90,000 or more next year. But if you have less than that number in your name alone, you avoid probate. And fortunately, you have a trust. So your trust owns everything. So Lisa, congratulations, you have $0. And the judge says, what are you doing here? You don't need probate. Your trust keeps living after you pass away. And your successor trustee, who you've named, kicks in. And they just do everything your trust says to do. And they don't need probate or a court or a judge to do any of it. So that's kind of the main difference between a will and a trust. A trust creates an entity, owns your property, avoids probate that way, whereas a will is just instructions saying where your property should go through that probate process.
One example I use or how I try to explain that is think of the trust as an empty box and you fill it with
Mhm.
your property. And if you don't fund it, fill it, then it really does no good. So you create the trust and you've got to make sure you title everything within the trust because otherwise it's really just a bunch of papers, as you say.
Yeah, that's a huge problem we saw at the public administrator's office a lot was people would have these really fancy, expensive trusts, but they didn't put anything in the trust. So it didn't work. And then it's you just threw your money away. If you don't fund the trust, which just means transferring property to it, it's worthless.
And the second part of my question, so when you have a trust, you still have a will called a pour over will. And why is that?
Yeah, so the see, it's not such a worthless document. Uh, we always have a will. In every plan we do, we're always recommending wills because you want that emergency backup in case something goes through probate. So I've seen time and time again, we tell our clients, update your beneficiary designations. We can't do that for you. Please, please update your beneficiary designations. To everyone listening, that's me telling you, go update your beneficiary designations because we've done trusts, we've transferred the property to the trust, and that client will either buy another house and not tell us and not buy it in the name of the trust. And then when they die, the trust doesn't own anything anymore because they bought a different house. And then that house has to go through probate and the trust doesn't work. So it's the same as if you don't name a beneficiary on your life insurance or your retirement account, that has to go to probate. So any asset that does accidentally end up in probate, we want this will there to catch it and pour it into your trust anyway, so that your trust still lives and still serves a purpose, and what you actually want to have happen happens.
Right. In even my parents were in a different state. That is helpful when it's a trust versus a will and probate, just because it's easier to manage from far away. But my dad forgot one little quarter of an interest in property. Here in Colorado, real property then would have to go through probate. In West Virginia, where I'm from, it did not, because it was less than $100,000. But we were and also we needed the original will, which I don't know what my dad did with it. So that's another thing. Make sure you always have the original will. But we were able to take care of that and not go to probate in West Virginia. But here it would have been different. So that's just another aspect. Something wasn't there. Also, please always have the original will.
Right. Yeah, originals are so important. And we tell people, look, we're making you copy sets of your plan, hand them out to your beneficiaries, your power people, your trustee, all that kind of stuff. But don't lose the originals and don't write on them. For the love of everything, don't write on your documents. You can accidentally revoke them. But if you lose those originals, there's a law in Colorado that says you lost them intentionally because you didn't want them to be found. So it revokes all the copy sets. So the copies are now worthless. So your originals are very, very important. And I saw a question pop up of where the heck do you store a will? That's a great question. It's like the number one question we get. And my answer is where to not store it. And that's in a bank, in a safe deposit box. Sorry, banks. Um, Banks are very, very tricky after the owner of the safe deposit box passes away. And sometimes they will require a court order to get into that safe deposit box, which means probate. And then you get a probate, you open the safe deposit box, and you pull out this really fancy trust that says, whatever you do, don't open a probate. Like, oh, great, we're already in it. So I recommend a fireproof safe in your house. If people have gun safes, those are fine. Otherwise, just any extra safe you can get. I'm not so much worried about people stealing your estate plan. There's nothing in it that they could use against you. We're not putting social security numbers in it or anything, or account numbers or amounts of money. It's just who gets what and who's in charge. So we've used little portable fireproof briefcases. So if there ever was anything, it's kind of your go box, and that's the thing you grab and just get out.
That's a great idea. And then that kind of leads me to the next thing, because it's also something of where to put it once we talk about medical directives and powers of attorney.
Yeah. So I'm happy to skip to the next slide and talk about powers of attorney. Any specific questions, or just want me to run through them?
So let's first go to medical directives versus medical powers of attorney, because I
Yeah,
think people get confused that there are actually two different aspects to this.
sure. So medical directives, I would say, is like the overarching bigger picture. Um, it's the big category that houses medical powers of attorney, HIPAA releases, and living wills. There's DNRs in there too, and some other things. But think of a medical directive as the big category, and then there's tons of little documents inside that category. So all of them are technically medical directives. The medical power of attorney is where you're naming an individual to act for you if you can't act for yourself. So um, if that's Alzheimer's, dementia, car accident, coma, like I said before, someone has said that you no longer have the capacity to make your own healthcare decisions. Who comes in and makes those decisions for you? And that's your medical power of attorney. If you don't have that document, the bummer part is the court will come in and appoint that person for you. just like we talked about with minor children. So you'd get a guardian appointed in a guardianship hearing, which can be like a $10,000 court hearing, where then a professional is appointed to um, make those decisions for you. And they're getting paid an hourly rate for the rest of your incapacity, which could be the rest of your life. So I've seen the lack of power of attorney documents completely bankrupt people's estates. And most people don't even know that they need powers of attorney. Um, a HIPAA release is another directive, and that's basically just saying who can be in the room with your medical power of attorney when they're talking to the doctor, who can call and see how you're doing, who has access to your medical records. So we usually list all your medical powers of attorney out in that document, but you can put your kids on there too if they're not already your power of attorney. You can put family members, anyone that, like I have a doctor who's a friend that I put on my HIPAA release, so I want them to know how I'm doing. Um, and then the living will, to me, is actually the most important document that I do for people. And that's kind of when people say medical directive, that's usually what doctors are referring to. And that is if I'll pick on myself, two doctors come in and they say, Jeff has no brain capacity. I don't know I'm alive anymore, and I will never know that again. But life support's keeping me going. How long do I want to stay plugged into that life support? Um, why I say that's the most important document is because that's a really stressful decision to leave to your kids, to leave to your family. It's probably not a conversation you're having at dinner every night. Most people have never told anyone how many days they'd like to be on life support because they've never thought about it themselves and they never wanted to talk about it. So I've seen the most and the worst fights when that document doesn't exist because most times people don't agree, or son comes up and says, Dad told me he wanted 5 days. And sister then comes up and says, Well, it's not what he told me. He said, keep me on forever. And then they fight. Then the word murder gets thrown around, and then they never talk to each other again. And we're very passionate about our goal of keeping families together. And I think this document does that more than any other document that we have, because you get to decide, you take that stressful decision out of everyone else's hands, and they can't fight about it anymore.
Remember when I was going through that with my own dad, and my girlfriend, who's a physician, said, You need to reread them. You might have been there when they did them because my parents actually did them in front of me, and it was very cute. They had to ask each other what they each wanted. They wanted to match on theirs, which you don't have to do, but they did. But she was right. It was probably over 10 years since they'd done it. And I had to go through all those steps at the end of my dad's life. So knowing and having read and knowing what he wanted was very important. So it's good to let those people know what is in those documents and yes, have them as well. Um, where do you recommend keeping those, especially for elderly people?
Sure. So a lot of people put their stuff in their freezer, which I mean, okay, go for it if you would like. Uh, I keep the entire estate plan together. So, like when we talked about don't put it in a safe deposit box, keep it in a fireproof safe. I recommend the originals go with all those documents in that fireproof safe. However, for all our clients, we make an extra copy that just says doctor across it, and we give that to them and instruct them to give it to their health insurance provider, their primary care physician, and if there is any other specialist that they're working with, they can give that copy set to them as well. The doctor should scan it and just give it right back to you.
Right. I also have my parents on my computer and I happened to be on a plane but I also had it where I could access it to my phone and send it to my brother in another state. So that's an idea as well because they don't, when they're in that situation, they just need to see it, not necessarily the original. So,
Yeah.
okay, let's go on to financial powers of attorney or general durable powers of attorney.
Yeah. So financial powers of attorney, not much different than medical powers of attorney, just in the role that they're doing is what's different. So the medical power of attorney was the one talking to your doctors, okaying surgeries, long-term care, hospice, anything like that, if you're incapacitated. The financial power of attorney, which a lot of people just refer to as a durable power of attorney, is the same thing, except this is the person talking to your banks, your financial advisor, your um, any financial institution that you have assets at. They are in complete and total control over all your money, all your assets, all your property, and your signature, which is a terrifying amount of power, but necessary if you can't make your own decisions, because the only other thing we have as an option is to go to court and get a conservator who's a stranger to make these decisions for you. So this, once again, is if you're incapacitated, Alzheimer's, dementia, car accident, coma, you can't make your own decisions. Who steps in and does that for you? For financial stuff, it's just your financial power of attorney.
Um, there's two ways I believe you could go ahead and have that active now or when you become incapacitated. So that's a decision you need to make because it is a huge amount of power.
Yeah. So you can normally they're set up to be active when someone becomes incapacitated. You can have an immediate power of attorney, which we do for spouses a lot. So Amanda, my wife, is my financial and medical power of attorney. She's my immediate power. So if I need someone to talk to the doctor or to the bank or anything like that, she can call and do that. She doesn't need to wait until I've lost my marbles, even though she probably already thinks that I have. But my backup people, they get what's called a springing power of attorney. So my my brother is my backup power of attorney. He doesn't get any power over my bank accounts or anything until he has a doctor's letter saying that I can't make these decisions anymore. And then at that time, his power kicks in, and then he can help out.
Okay. Um, Going back to trust, I did not ask you, we did not cover that there are different kinds of trusts.
Mm-hmm.
And so the most common in what we've been talking about is a revocable trust, correct?
Yeah, so there's a few trusts on this slide if everyone can see it, but um, revocable living trusts are the most common. I mean, I would say over 90% of people, if they have a trust, have a revocable living trust. And that just means you made it while you're alive, it exists while you're alive, and then once you pass away, it becomes irrevocable. So no one can change what you wanted to have happen. There are tons of other trusts, though. You can do a trust just for a house, and there's people have come up with fun marketing names for trusts. So you get all kinds of crazy trust names that are really just revocable living trusts by another name. There are gun trusts out there, though. Those can still serve a purpose. With changes in the law, they've become a little less valuable than they once were. Most guns can just be transferred through a regular trust. Um, there are, on this slide, specific irrevocable trusts that we don't normally recommend irrevocable trusts. However, in these situations where there is an individual with special needs or someone who qualifies for Medicaid, we are recommending trusts that are irrevocable because it protects those people from getting disqualified from their government benefits like SSI or Medicaid. So some of the trusts you see here are just basically different versions of special needs trusts. Our favorite is the bottom one. That's the third party trust. And what that means is if I am leaving to someone who has a special need or an intellectual and developmental disability, and there's a statute that has like qualifying disabilities on it, but if I'm leaving money to someone or an inheritance or a property or anything, and I know they're on Medicaid because of a intellectual and developmental disability, and I don't do a special needs trust, I just leave it to them. Let's say Sarah has an intellectual and developmental disability, and she inherits my house. She's now disqualified from Medicaid because there's very strict income and asset limits. It's like $2,000 worth of income and $2,000 worth of assets. You have to have less than that. If you have over it, you get disqualified. Your inheritance counts towards that stuff. So it instantly kicks you off your benefits, which is terrible for anyone that is on Medicaid because it's a pain in the butt to qualify. They pay for almost everything. So losing those benefits is horrible. A special needs trust inherits on behalf of Sarah or on behalf of the person with the special need. So it doesn't disqualify them from those benefits. They get their inheritance and they stay on Medicaid.
I think there was a question. Can you see that about
Yeah. Can a person with a financial power of attorney change your trust or beneficiary designations? Typical lawyer answer, it depends. Um, if you grant them that power in the financial power of attorney, yes. Um, the way ours are written is they can't really be doing that unless it aligns with your best interests. So, an example of that where we've had to do it was someone had a financial power of attorney, but they didn't have any beneficiary designations on their house. And so we did the financial power of attorney was able to create a beneficiary deed recorded on the house, and then that house avoided probate. So that is technically updating beneficiaries. And yes, you can definitely name a trust as a beneficiary, and that is actually my recommendation. Um, the When you have a trust, if you're not naming it as a beneficiary, it's not going to control any of those assets. So once again, we talked about if the trust isn't funded, it's kind of worthless. If you're not naming it as a beneficiary, why do you have a trust? It's kind of worthless at that point. You're just naming who you want to get the assets in your beneficiary designation, so you may not need a trust at all. But yeah, if you don't name the trust as a beneficiary, those beneficiary designations will either go to probate because there isn't one, or they'll just go to the people you named and avoid your trust completely.
And when I'm working with our donors, sometimes we'll talk about them putting assets, like retirement assets, IRAs, actually designating that into the trust and dividing that between their children. But if they want to carve out a portion for charity and they don't want to be taxed on those assets, then 10%, I'll use as an example, they go ahead and send to the Catholic Foundation. And then through that gift agreement that you mentioned earlier, they then designate where those funds will go, and then those will not be taxed. So
Yeah.
that's just a caveat that I try to point out to them when they're trying to do their whole planning and talking about the charitable aspect of their planning.
Yeah, and that's a great way to do it. And just another plug for the Catholic Foundation. There's actually tons of tax planning things you can do through the Catholic Foundation that Lisa's not even mentioning. So it's always worth. I tell my clients, I mean, obviously my Catholic clients, to always reach out to the Catholic Foundation if they're charitably inclined at all or want to leave to their church or anything like that, because you guys have so many cool strategies, and this is what you were designed to do, that other people just have no idea about. So, yeah, I mean, thanks for all the great stuff you do for people.
Oh, again, it's a blessing. One thing we didn't discuss, and since we are talking about charitable donations, is a charitable remainder trust. I've seen some of those lately. We did a very different one at the end of last year, a little more complicated. But a gentleman was selling a piece of property, put it in a trust, and he got the charitable donation right then, and it was great. And he will get the income on the property. Anyway, kind of complicated, but my point to that is there's different kinds of trusts to help you with tax ramifications. Like, for example, when you're selling a business or a piece of property. Do you see that?
Yeah, so there's like I said, all kinds of trusts. There's charitable remainder trust, there's charitable leads trust, and it's basically just when is the charity getting the money and when are you getting the money or when are your beneficiaries getting the money. And yeah, those are all options. Um, Probably not enough time to go into
Right.
the
No, I
facts
just,
that surround those, but yeah, there's definitely options out there.
and then one question we get frequently, I just moved to Colorado. So do I need a new will or a trust?
That's a great question. Once again, typical lawyer, it depends. Um, Most lawyers that do estate planning will offer free initial consultations to even just like look at your plan to see what it looks like, what's going on. Do you still have the same goals? We do that at our firm. But normally, just moving from one state to another does not mean you need a new plan. There's this thing called reciprocity, which means anything done legally that's valid in one state has to be recognized in another state. So the estate plans we do in Colorado are good if you move to Arizona and vice versa. But a lot of times when people move, they're buying and selling property, and it's the house that we have to take care of. Like maybe you need a beneficiary deed on the property you just bought, or you need to make sure the house you're buying gets into your trust that you have. So that's usually the biggest thing. And someone asked about ILITs. Those are my favorite. ILIT stands for Irrevocable Life Insurance Trust. And our firm actually doesn't do those. That doesn't mean they're bad. It just means that normally people aren't using them anymore with the changes in the estate tax laws unless they have over $30 million. Dollars. And I'll just be honest, our clients usually don't have over $30 million. Dollars, so we're just not doing them. But they can come into play. It basically lets you leave a very massive chunk of money for beneficiaries that can be completely tax-free and avoid the estate tax as well.
Um, One other question we get a lot is families, or not families, individuals who do not have someone that they want or can trust, have that trusted individual to be either their trustee or their personal representative. How do you handle those situations?
So the question is if they have someone that they can't name as trustee, or
No,
they're
that
just
they don't have anyone to name.
gotcha. So I guess to preface the question first is I always recommend if you have family members or people you trust, name those people. But if there is truly no one that we can think of or no one that's willing to do it, there are professional fiduciaries out there. And fiduciary is just a fancy name for someone that will be a trustee for a living. You know, you pay them like 150 bucks an hour, usually 250 bucks an hour sometimes, and they will be your successor trustee, sometimes even current financial power of attorney. It's tougher to find a medical power of attorney to do that, but there are professionals out there who that's their job and they're pretty good at it. We've worked with a bunch, so we would have recommendations if that's the route people want to go. Banks will do that too a lot of times if they have a trust department. I'm usually banks are not my first choice, but it doesn't necessarily mean they're the wrong choice. It's just have other options first.
I agree about banks because I also do the estate administration for the Catholic Foundation, and I think the other choices are better. And we also keep a list of those as well. We have a list of trustees, professional advisors to help with. It looks like we're down to probably about 4 minutes or so, 3 to 4 minutes. So are there any other questions and before we close? Okay, so Jeff, do you have anything in closing that you wanted that I didn't cover in my questions?
Just on the last slide, I think I may have skipped over it. Most people don't realize that estate planning is so much more than just the documents, and so much more than just a will or a trust. There's lots of documents that keep you out of court, not only after you pass away, but while you're still alive. And there's so much that goes into the planning. I could do an entire presentation on why to not do this online. You don't have to do it with us, but do it with somebody. Don't go online and do your plan because you really do need an analysis of what do you own and how do you own it and what debts are there and how are creditors going to play in and are you charitable and how do you want to leave those charitable gifts and what's the best most tax advantage way to do that stuff. And while AI is great, it's not there for estate planning yet. So I guess the last thing I'll close with is have the conversations. The conversations behind your documents are just as important as the documents themselves. There was this big trend for people to want to keep their plan a secret and not tell anyone about what they're going to inherit or how they're going to inherit. And while you don't have to tell them a dollar amount, at least tell them they're inheriting and what the percentages are and who's in charge. Because if it's a surprise, then people fight and then the family falls apart. So have the conversations. It's important.
And then if you have further questions or you think you do, you're happy to email us and we will forward those questions to Jeff or I will answer them. And also we will send you a recording of this. If you had to go off early, you will still get the recording. Even if you listen to it, we will send everyone the recording just because there was so much information on here. And again, happy to work with you and help you in your planning. Thank you to everyone. And thank you for attending and God bless.
Thanks so much, Lisa.
Thank you. Thank you so much. Thanks for your time.
Yeah, thanks for everyone for putting up with me for a while.